So thank you for being part of today's Nonprofit Resource Hub webinar. My name is Noel Robb, 5-Star Advertising. We're a proud associate member of the Nonprofit Resource Hub, or NRH for short. NRH is a trade association whose mission is to serve, be a resource to, educate, and connect its members to the nonprofit community. At the same time, NRH serves the nonprofit sector as a bridge connecting nonprofit organizations to each other and to helpful resources. And that's part of what we are doing here today. We provide nonprofits with resources to help their organizations grow and thrive. We share a directory of our associate members. These are vetted, trusted providers and advisors who deliver quality products, services, and education to the sector. NRH hosts networking sessions and events to foster opportunities for collaboration, both with other nonprofit organizations and with experts serving the sector. We encourage each of the nonprofits joining us for today's webinar to join NRH as a nonprofit partner. By design, there is no cost for nonprofits to join as our nonprofit partners. Please go to our website to learn about all of the benefits. Thank you to, of course, our board, consisting of Serini Associates, Certilman Balin, Nonprofit Sector Strategies, Triumph International Business Consulting, and Vanguard Insurance Agency. And thank you, of course, to all of our associate members as well. Without further ado, we are very pleased to introduce today's speaker, David Goldstein from Certilman, Balin, Adler, and Hyman. David, take it away.
Thanks for joining us today. And please feel free to ask questions as we go along, and either I'll get to them throughout the program or we'll save some time at the end, one or the other. So our subject today is part 2 of our nonprofit governance bootcamp. And we're going to pick up where we left off last time with the fiduciary duties of nonprofit directors. And we'll certainly have time to get to some traps for the unwary as we proceed through the PowerPoint. And hopefully also we'll have some time to talk about some enforcement actions and litigations as we move forward. So the fundamental precepts in the area of fiduciary duties is that directors of nonprofits have legal duties, often referred to as fiduciary duties, and there can be personal liability to directors for breaching these legal duties. And we'll see that in some of the litigations and enforcement actions that we look at. The 3 fundamental legal duties of a nonprofit director under New York law are the duty of care, the duty of loyalty, and the duty of obedience. The duty of care is basically the director's oversight function, and it's set forth in Section 717A of the Not-for-Profit Corporation Law, the NPCL. A director must discharge the duties of his or her position in good faith and with the care an ordinarily prudent person in a like position would exercise under similar circumstances. Now, this is not oversight at a 50,000-foot level. This, in fact, requires familiarity with the organization's finances and activities and regular participation in its governance, and we're going to be drilling down on that throughout today's program. One place where we can see the duty of care applied to a litigation context is in the Healing Arts Initiative lawsuit. You have that in your materials, and we're going to get to your supplementary materials in a little bit, but it includes this lawsuit from April 2016. So you'll see when you look at this lawsuit that it was brought in the New York State Supreme Court in New York County, and the defendants were a whole bunch of individuals. And in fact, those are the individuals who are on the board of directors of this nonprofit. So here the directors were sued in their personal capacity as a result of allegations of breach of fiduciary duty in the course of their service as directors of this organization. So here's an excerpt or two from this summons that's in your materials. And it says that this action is an action to hold accountable the directors of Healing Arts Initiative who, in violation of New York not-for-profit corporation law, section 717, which we just talked about, and 720, and other applicable statutory or common law, have neglected, failed to perform, and or violated their duties, including but not limited to their duty to act in good faith and with the care of an ordinarily prudent person in a like position under similar circumstances in the management of the organization. And this resulted according to the summons, in $750,000 being stolen by 3 former employees, the hiring of non-independent auditors, negligently hiring employees, and otherwise breaching their duties to HAI. The foregoing actions constitute, among other things, breach of contract, breach of fiduciary duty, and violations of 717 and 720. 720 basically allows you to bring an action to enforce the fiduciary duties that directors have under 717. Plaintiff expressly reserves the right to amend its claims to include other causes of action and other parties. Please take further notice that the relief sought in this action is damages in an amount not less than $750,000, believed to be foreseeably and proximately caused by defendants' conduct referenced above, that is, their breach of fiduciary duty, their lack of oversight, plus attorney's fees and punitive damages and removal of the board of directors, as well as any other relief that the court deems just and proper. So that's what happens when a board goes off the rails in terms of fulfilling its fiduciary duties, and particularly the oversight duty, the duty of care. Let's take a minute to look at a roadmap of how to fulfill the fiduciary duty of care so that you don't wind up in the crosshairs of a litigation. And you've got a bunch of materials that you'll be sent. If you haven't received them already, you'll get them shortly after the program. These materials will help put some meat on the bones of the duty of care. First among them is right from the start, responsibilities of directors of not-for-profit corporations. It's a publication by the Attorney General's Charities Bureau. It's written for non-lawyers. It's tremendously accessible, and in 8 or 9 pages, really provides some helpful examples and context of how a board can fulfill its fiduciary duties. And honestly, I suggest that people who are on boards read this at least once a year just to kind of ground themselves and refresh their recollection. You've also got in your materials a 1997 case decided under the not-for-profit corporation law by the Board of Regents in the Adelphi University matter. It was subsequently affirmed by a court that looked at the same fact pattern. And it's a very helpful, it's lengthy, and in fact, that's what makes it so useful, because the Board of Regents in this decision really walks through in great detail the fact pattern and how the board dealt with the situations they were faced and where they dropped the proverbial ball. You've also got more recent litigation from 2019, I believe, in the Dowling College bankruptcy. And there, the unsecured creditor trustee sued 13 board members of Dowling College, as well as the CFO. And there too, this is not a decision. What you have in your materials is the complaint in this action by the unsecured creditor trustee, but it's very helpful in laying out the fact pattern and the various decision points, actions and inactions that the board took that got them in hot water. Internal controls are a critical part of the duty of care, and there's a Charities Bureau publication in your materials on internal controls and financial accountability for boards. And again, that's written for non-lawyers, so it's very accessible. Policies and procedures, there should be written policies and procedures developed and approved by the board with the assistance of accountants that specialize in the nonprofit sector. Again, that's a critical part of oversight and the duty of care. And then there's the critical role of the audit committee. Hopefully we'll have a little time later on to talk in a bit more detail about that. Audit oversight is an essential part of the nonprofit governance regime. And the audit committee is so important that it is the only committee that has an entire section of the not-for-profit corporation law dedicated to the role of the audit committee. And a key piece of the audit oversight component is that members of the audit committee have to meet a rigorous independence requirement that's spelled out in the not-for-profit corporation law. So let's move to the duty of loyalty. The duty of loyalty requires that a director act in the interest of the organization. It requires undivided allegiance to the organization's mission when using the power of his or her position or information concerning the organization or its property. The place that we see the duty of loyalty most commonly being relevant is in the area of conflicts of interest and related party transactions. That could be the subject of New York regulation of those sorts of transactions, could be the subject of an entire webinar in and of itself, and maybe that's something that we'll do down the road. Just take away the fact that New York's regulation of conflicts of interest is, in the estimation of the Attorney General, the most rigorous of any state in the country. And I certainly would concur with that. So there's a lot there, and that's one of the ways that the duty of loyalty is implemented in the nonprofit context. So the third fiduciary duty is the duty of obedience. It's the least understood and most often neglected of the three primary legal duties. Why? The other two primary legal duties exist in the for-profit world, but the duty of obedience is strictly a not-for-profit law concept. Sounds kind of old-fashioned, but it's critical to understand and get your arms around. And what is the duty of obedience? It's to ensure that the organization complies with applicable laws and regulations, and also its internal governance documents and policies. So basically there are two tracks. One is the internal track, internal governance documents and policies, and the other is external laws and regulations that apply to the corporation. As you can understand from thinking about it for a moment, compliance with applicable laws and regulations is quite a task because there are multiple layers of laws and regulations, federal, state, and local. And just one quick example, in the area of lobbying by nonprofits, there's federal regulation under the Internal Revenue Code, there's New York state law, and there are local laws on the local level in many jurisdictions in New York state relating to lobbying, and that's just one example. The compliance with laws and regulations is most often in the context of compliance with the not-for-profit corporation law, which of course governs New York nonprofits and other New York entities that operate in the nonprofit sector. For instance, education corporations and religious corporations are also governed by the not-for-profit corporation law. And we've discussed how, in addition to the not-for-profit corporation law, which should be in front of every nonprofit on a continual basis, there are additional layers of laws and regulations that nonprofits have to be aware of. So if you were with us for part one of this presentation, which was, I think, in mid-December, and you can certainly find it archived on the Nonprofit Resource Hub's website, you'll remember that we talked a lot about the pandemic and the impact of the pandemic, and to what extent the not-for-profit corporation law may have been adjusted as a result of the pandemic. And the bottom line is there was really only one tiny adjustment of the law. to allow membership meetings as opposed to board meetings, which could always be done remotely, to allow membership meetings to be done remotely, and that's only for a limited period of time, and it's got a sunset provision built into it, so that special provision expires by its terms at the end of December of 2021. And the principle there is that the standard, and we talked a lot about this last time, the standard under the not-for-profit corporation law is not at all best efforts under difficult circumstances will suffice. That is not the standard. This is a law. It has mandatory requirements and procedures. Many of them, in fact. There are some bright lines that are rigid, inflexible, and unforgiving, regardless of the circumstances. So it's not at all a best efforts test. And one doesn't get any credit for being a director or officer of a nonprofit that is giving of their time and energies and probably money to on a volunteer basis. That does not change the fact that there are legal requirements that you need to meet under the law. So in terms of the internal focus on the duty of obedience, and that's compliance with internal governance documents and policies, the two documents that we see most often implicated here are the certificate of incorporation and the bylaws, which really are the cornerstone documents of nonprofit governance. Keep in mind that your corporate purposes are set forth in your certificate of incorporation, and the legal principle at play here is a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty. One of the central oversight functions of directors and officers of nonprofits is to make sure that the use of assets is consistent with the purposes in the certificate of incorporation. This is really a critical issue. It comes up all the time in the day-to-day operations of nonprofits. I had a phone call recently from an accountant who has a client that started a wonderful new program in response to the pandemic. The program addresses food insecurity and food needs in the community. One problem, and it's a fundamental and significant one, this activity, though vitally important, falls outside the purposes set forth in the certificate of incorporation of this nonprofit. Again, the legal principle is a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty, and there's potential personal liability of board members for failure to strictly adhere to corporate purposes, again, no matter how worthy the endeavor is. So there's an answer here, there's a clear track that needs to be followed to resolve this problem. And that is that the organization that is desirous of this program to address food insecurity as a result of the pandemic is going to be able to engage in this vital activity while protecting the board and officers from breach of fiduciary duty and potential liability. And the way to do that is under the not-for-profit corporation law to amend the purposes in the certificate of incorporation. That's a process, however, with both an internal and an external component. The internal component is that the board has to approve the change in corporate purposes. And if you're a membership nonprofit, your members will also have to approve it. If you're a charitable nonprofit, you'll have to submit a petition for approval to the Attorney General. And all of those things will have to happen before the certificate of incorporation can be amended by a filing with the New York Department of State. So this kind of brings to the fore a fundamental tension between the desire to have nonprofits evolve to meet the needs that they encounter and the static purposes that are set forth in a certificate of incorporation. This is such an endemic problem that the Nonprofit Revitalization Act that went into effect on July 1st, 2014, changed a provision with respect to the purposes clause of a certificate of incorporation, and effective on July 1st, 2014 and going forward, A new corporation, when it incorporates, can state as its purposes that the corporation will do anything that's permissible under the law for a charitable nonprofit, or if you're a non-charitable nonprofit, for a non-charitable nonprofit to do. And this eliminates purposes that are static and need to be continually looked at and adjusted to meet needs that evolve over time. This really is a huge problem that continues to impact nonprofits that were formed before 2014. And I see it all the time in my practice. One way that I've seen it a number of times is organizations that were literally started to research a particular area of need in our society. And as you might imagine, after researching that area of need, there was an evolution into activities to address that area of need. But the certificate of incorporation was never amended. So decades later, it still said that all the corporation was permitted to do was research in that area. So this is, again, an endemic problem, and it's critical to keep an eye on the purposes in your certificate of incorporation relative to your activities. I had a recent call from a concerned board member of a nonprofit, not a client, but someone who's on a board and was concerned about a particular series of governance actions that the board chair had initiated. The board chair had asked the board to vote by email on nominations for both the board and for officer positions. The chair stated in the email to the board that while normally the board would have a meeting to vote on nominations, because of the pandemic, the board would vote by email instead. So this is another trap for the unwary that is embedded in New York nonprofit law. Email voting by the board of directors is, in fact, an impermissible shortcut that you have to make sure to avoid. There are only two ways for a board to act under New York nonprofit law. The first is at a meeting, which can be in person, by conference call, or by video conference, or alternately by unanimous consent in lieu of a meeting. The unanimous consent can be by email or it can be in writing, but it must be unanimous, and that is not the same as voting. So those of you who've heard me speak before probably have heard the story about my client a few years ago that was a national nonprofit incorporated in New York with members throughout the country and board members throughout the country. And there were 50 members of the board and 49 of them consented by email to a board action that had been proposed. The 50th was in a coma at the time and thankfully fully recovered, but as a result of being in a coma, was unable to consent at all. The 49 consents were meaningless because there couldn't be unanimous consent without that 50th consent. So the board had to schedule a special meeting, and the board voted at that special meeting, which happened via conference call to approve the transaction. But again, that unanimous consent was in fact not unanimous, and because you can't vote by email, the 49 consents were absolutely not effective. The effects of missteps here are that board actions are not properly authorized, which would constitute a breach of fiduciary duty and potentially expose the board to personal liability based on breach of duty claims. I see a couple of questions. I'm going to look at them quickly to see if we've covered them. I think we have. To the two questions posed so far, one about certificates of incorporation and one about bylaws, please feel free to reach out to me offline. My contact information is on the PowerPoint, and we can discuss your questions further. But I think we've kind of covered them as we've moved through. So, all right, documenting corporate action and compliance with internal and external requirements is critically important. And again, there's no dispensation for extraordinary circumstances, pandemic or otherwise. Minutes are critically important. Minutes can be a problem if there's too much detail, and certainly if there's too little detail. The way I look at minutes, obviously they have to reflect what happens at the meeting, but minutes really, when you look back at them forensically, and all nonprofits should do this, either have their governance committee do this, or have their attorney do this, or have the attorney and the governance committee do it together. The minutes really should provide a checklist to demonstrate that the board has fulfilled its fiduciary duties. And it's particularly useful to look at the minutes after the fact that way, because it's very often possible to the extent that the board didn't do it right in the first place, the board is really able to go back and retroactively correct many missteps. So looking at the minutes after the fact to see if in fact they do provide a checklist that you as a board have fulfilled your fiduciary duties is tremendously adaptive and useful. The minutes and the paper trail are incredibly important also in connection with conflicts of interest and related party transactions under New York law, and also under a compliant conflict of interest policy, which each New York nonprofit should have. You're required to have every director, every officer, and every key person, which is defined under the statute. Every person in any of those three classes needs to make an annual written disclosure under the conflict of interest policy, and ongoing disclosure to the extent that any conflicts or related party transactions arise during the course of the year. So there again, the paper trail is critical. The minutes of how the board handled any disclosures of conflicts are critical. And what you need to keep in mind is that you can do everything right in the governance context. And if 2 or 3 years down the road, someone is questioning your governance or questioning the validity of decisions and actions by the board, the fact that what you did is not properly documented in the minutes makes it really hard for you to establish that you fulfilled your fiduciary duties. So minutes play a critical role. And here too, the effect of missteps is to open yourselves up to breach of fiduciary duty, allegations, and potential personal liability. So if you've heard me speak before, you've heard these words uttered. Governance, it's not rocket science. And what it is process. There are procedures, mandatory requirements, they have to happen. I think we see already, and we'll continue to see as we move through today's PowerPoint, that no board can do this on their own. This requires board education. And a board that doesn't receive board education is really putting themselves and their organization in jeopardy. Frankly, you can have a board full of lawyers, and if they're not nonprofit lawyers, and I have a client that's a lawyers organization, they need help like every other board because this is chock full of mandatory procedural requirements that are not waivable. And if the board is not educated as to where those lines in the sand are, inevitably you'll trip over them. And this awareness of those lines in the sand is necessary, again, even under extraordinary circumstances like the pandemic. And you can see that in the best of times or in the worst of times, this requires tremendous discipline and commitment to compliance on the part of any nonprofit. So let's talk for a minute about the bylaws. The bylaws are one of the cornerstone governance documents, and basically the bylaws are a contract between the organization and the board, and if you're a membership nonprofit, between the organization, the board, and the members, as to how the organization will operate. Bylaws are rules by which legitimate corporate decisions are made, and following these rules is a roadmap to protect directors from breach of fiduciary duty allegations. Of course, the inverse is also true. Not following your bylaws is the best way to walk right into breaches of fiduciary duty. Really important to remember that as opposed to your certificate of incorporation, which is reviewed by the state, and it can't be changed unless the state signs off, your bylaws, in almost all cases, are not at all reviewed by the state. And amendments can be too easy and can actually get you into trouble. First, you've always got to follow the roadmap that your bylaws provide. It's a roadmap to compliance. It's a roadmap to valid corporate decisions. And it's a roadmap to protect board members and officers. Make sure, however, that your bylaws are consistent with the not-for-profit corporation law. The bylaws should be drafted by an attorney, and no changes should be made except by an attorney. Failure to strictly adhere to requirements of bylaws or having bylaws that are inconsistent with the law is, by definition, a breach of the duty of obedience. Consequences can include undermining the validity of corporate decisions and actions, and governance mistakes in these areas are another potential trap for nonprofit directors and officers. I should say that most of my practice involves working with boards representing nonprofits, but we do get retained on a fairly regular basis to question boards and challenge boards and sometimes sue boards for breach of fiduciary duty. And these sorts of governance missteps in terms of bylaws that have provisions that are either not followed or that are followed but are inconsistent with the law come up all the time and really open the door to tremendous exposure to boards. So this is definitely a preventable issue and preventable exposure, and proper governance will make sure that that this doesn't become an exposure of your board and your organization and your individual directors. Very often we see provisions that are completely logical, drafted by the board or drafted by lawyers on the board, again, who aren't nonprofit lawyers and who aren't familiar with the statute. And those are followed, but because they're inconsistent with the law, they cause the organization significant problems. An example that I see fairly regularly is provisions about consents without a meeting by a certain percentage of directors being a way that the board can act. And as we saw before, that doesn't work under the law. So we want to make sure that our bylaws are consistent with the law and then we follow them. Okay, another trap for the unwary. I'm going to pause for a second to see if we've got some questions. So I see a question about the date of the annual meeting, again, I encourage you to reach out to me offline to discuss that. This is something that actually came up recently. I have a new client that has been having an annual meeting in a certain month every year, following the provision in their bylaws that says you've got to have your annual meeting on the second Tuesday in whatever month. And they've been scrupulously following that for many years. Turns out that when I got a certified copy of their certificate of incorporation, which dates from the early 1900s, there's a provision in there that requires their annual meeting to be held in a completely different month. And in a situation like that, the certificate of incorporation trumps the bylaws, and so the bylaws provision is ineffective, and the organization would have had to amend the provision in the certificate of incorporation. So lots of technical distinctions here, and the questioner, please feel free to reach out to me and we'll go into more detail offline about your question. Okay, so the not-for-profit corporation law, I think, as we've seen, itself is full of these bright lines that are only bright if you know where to find them. And there are all sorts of, and I refer to this as the not-for-profit corporation law trap, because these are holes that you can fall into very easily, because it's somewhat counterintuitive to think that they exist in the first place. So for instance, when approving officer compensation, the law requires not just a simple majority of those board members voting at the meeting. There's in fact a supermajority requirement written into the law. So it's very important to be aware of that, so that you don't trip over it. Another supermajority requirement in the law is that to set up an executive committee, as opposed to other committees, the executive committee also has a supermajority requirement. That applies. And when we're trying to remove a director at the board level, there's also a supermajority quorum for that kind of an action. Something that I see happen all the time. Again, another new client of mine wanted to schedule a membership meeting, and I looked together with them at the provision in their bylaws that they also have been very carefully following for years. They're a membership nonprofit, and it said that membership meetings can be held upon 5 days' notice to the members. Great, that's what it says. Let's follow it. Not really, because the not-for-profit corporation law has a trap when it comes to notice of member meetings, because there's a non-waivable provision that requires a minimum of 10 days notice for member meetings. And similarly, if you're dissolving a nonprofit, there's a provision in the context of a membership nonprofit that people often trip over, that requires notice of the meeting for the members to vote on dissolution to be sent to the members by certified mail. So their email isn't enough, email and mail together aren't enough, you actually have to send it by certified mail. So these are just examples. The law is chock full of these procedural requirements that usually are not intuitive and are very easy to trip over. Another trap for the unwary is the process trap. And we've seen a little bit of an example of that with respect to the requirement that the only way you can amend your certificate of incorporation is by filing it with the state and getting all of the required consents before you do that. Had a client come to me a few years ago, and a problem came up, and I looked at their certificate of incorporation, which I ordered a certified copy of it from the Department of State. I looked at it, and I gave them an answer under their certificate of incorporation, and someone who'd been involved for decades said, well, wait a minute, we changed the certificate of incorporation to address that. When did you do that? Oh, in the 1970s. Okay, we double checked with the state, and there was nothing on file from the 1970s. And it turned out that one of the officers did an incredibly diligent search and found documentation of this effort to amend the certificate of incorporation, including approval by the membership. And there was a very large membership in this organization. The membership, the board approved it, the members approved it. Even the regulatory agency, in addition to the Department of State, the specific regulatory agency that regulates this nonprofit, approved this filing. And then what the nonprofit did was they took all of those approvals and put them in their safe, thinking that they were done. And there they sat. And the reality was that their certificate of incorporation had not been amended. The amendment is not effective unless it's in fact filed with the Department of State, and that's required. And so process is king when it comes to that. And we talked about the process to amend corporate purposes, and that this is the context in which that issue arose. Another related issue is a mission statement in the bylaws. This is something I see all the time, and it's a very dangerous practice. I really try to discourage nonprofits from putting their mission in the bylaws. And here's the reason, and I think you've seen, you can connect the dots from what we've already discussed. The place where you're required to have your purposes is in your certificate of incorporation. The certificate of incorporation trumps the bylaws. So to the extent that you have, and you must have purposes stated in your certificate of incorporation, that is what governs. And very often the certificate of incorporation is the first document that nonprofits look at. It gets filed, and then it gets filed away, and boards and officers don't look at it for sometimes years, sometimes decades. The governance document that boards look at all the time are their bylaws. So it's very convenient to have your mission statement in your bylaws. And as we said earlier, it's very easy to amend your bylaws. So what I've seen many, many times is bylaws that have a mission statement that have been amended over the years as the nonprofit has successfully evolved and changed its mission to meet challenges that it faces. And the board at the time of adapting the mission statement was always very comfortable that they'd done whatever they needed to do to update their mission. And of course, that couldn't be further from the case, because that mission statement in the bylaws is completely ineffective vis-a-vis the purposes in the certificate of incorporation which govern. So that's something, what if clients want to reference their purposes in their bylaws, I always ask them to cross-reference it to their certificate of incorporation, because that is the provision that governs. It's very important to be aware of that. Again, not rocket science. Process, priorities, authority, but not rocket science. So another area, and I apologize if I'm racing through this, we've got a lot of ground to cover. And I encourage people to reach out to me offline, and we can go into more detail on questions that you may have. The area of committees is one of the areas that's fraught with technical requirements, again, that are completely counterintuitive. So nonprofits trip over these all the time. So there are two kinds of committees that you can have under the not-for-profit corporation law. One is a board committee, and that's the kind we're most often used to seeing. Examples of that are the executive committee, the audit committee, nominating and governing committee, development committee, and others. And what are some of the requirements that apply to a board committee? The key requirement is that every board committee must have at least 3 directors, and only board members can be voting members of a committee. You can have non-board members as advisors to the committee, but the only full-fledged voting members you can have have to be directors, and there have to be at least 3 of them. Board committees can have responsibilities that have some level of board authority. There are some limits in the law. It's very important to be cognizant of those. There are about 8 areas where a board committee cannot act, and those are non-waivable, and they're in the law, and it's very important to be aware of those. But outside of those 8 specific situations, board committees can have authority and can act on behalf of the board. The other type of committee in the nonprofit context under the law, which is completely confusing, this is where everyone gets tripped up, is something called a committee of the corporation. It's a misnomer, right? Because on a practical level, a board committee is also a committee of the corporation. But don't go down that road, because that's the terminology that we're stuck with, and that's the terminology that the statute uses, at least for now. Hopefully will prevail on the legislature to change it at some point. So board committees have to be comprised of at least 3 board members, and they can have some piece of board authority. Committees of the corporation can have non-board members only, can have a mix of board members and non-board members, or can also just have non-board members or board members. And the key here is that a committee of the corporation is strictly advisory. A committee of the corporation can be delegated with no board authority. And so the way I like to think about committees of the corporation, rather than thinking of them as committees of the corporation, they're really advisory committees, and that's what they're limited to, advising the board, not exercising any even tiny slice of board authority. So the critical distinction is whether or not board authority is delegated to a committee and who is on the committee. It's critical to have a description of a committee's responsibilities somewhere. I like to put a default description for committees in the bylaws. So if we have a nominating committee, this will be the responsibilities of that committee. And I think it makes sense to say in that description in the bylaws that the board can change the description of what this committee will do, either by board resolution or by adopting a committee charter, or of course by amending the bylaws. But it's important for the board to understand and for the committee to understand what its responsibilities are and what the limits of those responsibilities are. So we've talked a lot about oversight, and we'll talk a little bit more about it. And that's what ties back to the duty of care that's enshrined in section 717 of the statute. It's important to remember that adequate oversight on the board level is absolutely inconsistent with the concept of trust. Unfortunately, I have a steady stream of nonprofits that find their way to me after there's been a significant fraud. And inevitably, there was trust, and trust is really inconsistent with adequate oversight and fiduciary duty. So that I think that's a fundamental precept that directors and officers should keep in mind. The concept of we're volunteers, we're just doing good, so what's wrong with a little trust? That doesn't work, and it's not consistent with directors fulfilling their fiduciary duty. Very often we see huge governance problems, even where there's a very smart and very accomplished board. And if you read through the resources on the Dowling bankruptcy, the litigation complaint that's in your materials, and the Adelphi decision that's in your materials, you'll see that the boards of both of those entities were full of people who were bright, accomplished, successful. Doesn't matter. Trust it doesn't work, and oversight at 50,000 feet without the detailed information and analysis that's required, that is a recipe, frankly, for disaster. Something else to keep in mind is that the Ostrich Defense of burying your head in the sand, and if you're of my vintage and my age, you may be familiar with a TV program back in the day called Hogan's Heroes, and there was a character there whose name was Sergeant Schultz, and his tagline was, "I know nothing, I hear nothing, I see nothing." That defense, if there's a screw up, won't get you anywhere under New York law. You can't say, I didn't know what was going on. That's a critical aspect of the oversight responsibility, is you as a director or officer have not only a responsibility to look at, analyze, understand what you receive, but also to make sure that you receive timely and sufficient information so that you can exercise your oversight. And the absence of that information, I didn't know any better, burying your head in the sand, that will, and by the way, not coming to meetings or not receiving sufficient information. If you do come to meetings, none of that will be exculpatory. And I would, whether or not we have time for today, further on in the PowerPoint, there's a summary of the Dowling complaint, and that really hinged on the failure of the board there to insist on receiving. So you as a director or an officer have an affirmative duty as part of your oversight responsibility, as part of your duty of care, to seek and insist on and receive, with no other option and no excuses, sufficient information. And that really is the fulcrum of the complaint in the Dowling bankruptcy, in the suit against the trustees, because it was alleged that they failed to do that. So we talked briefly about the importance of the audit committee to oversight, the audit process, and the role of the auditor, and having an auditor that's experienced in the nonprofit sector is critical. The financial accountability, financial transparency, and a backstop to prevent misappropriation and fraud. The audit and the audit committee and its role in that process are critical. I had a very senior person in the enforcement section of the Attorney General's Charities Bureau tell me that they had never seen a significant fraud where, if the audit process and the audit committee were working properly, the fraud would have been detected and prevented before it got to the level that it did. So that process is a critical part of oversight, and the legislature acknowledged that, again, by devoting the only section where the committee, where a committee has its own section of the not-for-profit law completely dedicated just to that committee. So something to avoid in nonprofit governance is the opposite of what we've been talking about up to now. What we've been talking about is how lack of significant and sufficient oversight will get you into trouble. It's also important to avoid overkill. We've seen that the not-for-profit corporation law is incredibly demanding of New York nonprofit boards and officers. And so it's important to be careful not to add extra fiduciary duties where they don't already exist. So for instance, and I think I'll stop after this slide, very often boards say to me that they want to mandate a very significant number of meetings in their bylaws. And my answer to them is that I would love for them to have incredibly frequent board meetings. The more the better, because obviously that goes to oversight. But I would be cautious about mandating that in their bylaws, because if you put in your bylaws that the board will meet every month, and you do that for a couple of years, and then after a while, you're meeting 10 times a year, 9 times a year, 8 times a year, the board has just breached its fiduciary duty under the bylaws, because it did not meet every month, and that's a breach of the duty of obedience. Conflicts policies are, as we've seen, incredibly demanding under New York law. So there too, an unnecessary burden that I see nonprofits sometimes walk into is the law requires that the demanding conflicts of interest policy that's required under New York law applied to officers, directors, and key persons. To apply the New York level of conflict of interest procedures to anyone who doesn't fit into those categories is, in my mind, just setting a board up for breach of fiduciary duty. So have the extensive requirements applied to boards, directors, officers, and key persons as required by the statute. And if you want to have a conflict of interest policy that applies to people outside of those categories, senior staff, other employees, it's absolutely fine, but use a separate policy that doesn't have the level of mandatory requirements that your board level policy has. So on that note, I think I'm going to stop, and I encourage you to look through the rest of the PowerPoint. If you have questions, certainly email me or call me. And I thank you very much for your attention.
Thank you, David. That was incredibly informative. Hi, everyone. I'm Ken Serini. I'm the managing partner of Serini Associates. First of all, I want to thank all of you for attending our webinar today. We'll be sending a survey to everyone, and we just ask if you can please take the time to fill it out and allow us to know if we're meeting your needs, what other things you would like from our organization. Again, the purpose of the NRH is here to be a resource to you, the nonprofit sector. So again, anything we can do, that would be great. Please join us on March 25th from 12 to 1 when Joshua Pesky from our associate member Roundtable Technology will be presenting from uh-oh to aha, transforming your organization with great IT. Also, please visit the www.nonprofitresourcehub.org for more information and how to become a nonprofit partner so that you can enjoy all the benefits of NRH membership. If you have any questions, feel free to reach out to Danette O'Connell, our president, at d'Oconnell, D-O-C-O-N-N-E-L-L, at nonprofitresourcehub.org. And once again, we thank you very much for being part of today's presentation. And David, you did a tremendous job, so thank you. Take care, everyone. Again, any questions, anything you need, just please reach out to us. So long.
So long. Thanks, everyone.